Von Zell Hall.
I missed the opportunity to tell you.
Notice how the judge starts with casual banter. But in just seconds, the mood shifts to something much heavier. Courtrooms often swing like this, from light to life-changing in the blink of an eye.
I told you so earlier. I really regret it.
Did you?
It was a cap, and they got permission, and we revoked them today. Meant to.
You got to take advantage of those opportunities. I give them to y'all, so it's okay. You're here for her. Good morning. Are you Von Zell Hall? And Mr. Hall is charged with the offense of murder in cause number 24, DCCR 1747. And what is the announcement?
Your Honor, we've received a plea bargain offer that we've been unable to reach an agreement on that offer.
Okay.
And I've informed Mr. Hall of that offer today. It actually has come down a bit, but I've updated him on that. Again, we haven't been able to come to an agreement.
Okay.
And I see no reason why it would come down any further, Your Honor.
Is that a new rejection that
Yes,
you
Your
have? Okay, if y'all will sign that so I can get it over here, and that way I have that. What's the offer?
It's 35.
35 years. That's not just a number, it's essentially a life-defining choice. Would you take the deal, or risk everything with a jury? Let me know what you do in the comments.
5 years.
So, Mr. Hall, if you don't want to take that offer of 35 years and you want your case to go to trial and let a jury decide, sign that document real quick and then we'll get it set for trial.
And Your Honor, this is not a cap. This is straight.
Okay. Well, your options are to take 35 years in prison or to go to trial.
So if I sign this, I'm accepting it?
No, if you sign that, that's the rejection that says you want to go to trial, that you don't want the 35 years. If you want to plead guilty and take the agreement for 35 years, there's some different paperwork y'all can do this morning and we'll get that taken care of. But if you don't want to take that offer, then we'll let a jury decide.
And I don't know if it's on that rejection, but I did discuss a possible 40-year cap with Mr. Patuska, if he wants to talk about that.
Do you want to talk?
I've told you about that.
So either you want to take the 35, take a 40-year cap and let me decide. I could give you 40, I could give you less, or let a jury decide if you're guilty and what your punishment is. That's your options.
You want to reject that or discuss further?
I'm taking 40-year cap.
Okay. Well,
Yeah, I'll go do that paperwork. I'll hold it for the paperwork then. So I'll delete this. Oh wait, there wasn't anything. You can
No, they
delete it
hadn't
on your.
sent it to
Y'all
me
hadn't
yet,
sent it
Judge,
yet.
so-
Okay, I'll hold it then. Let me. Well, Mr. Matuska, I'll let you take care of that, and then I'll do Garner in that one when you're finished. Get you all taken care of. Let's see. Ms. Holmes. I don't. Oh, did he? Let's see. What was that on? Gabriel Smith. It's here. Mr. Kimler on Gabriel Smith. Gabriel Smith.
I think this one we did.
I know, I need to do the rejection.
Oh,
Yes, please, ma'am. All of her, if you want to see that old PSI, it's got all those listed. We could get you a copy at least of that page, I'm sure.
The real question with Louisiana, felonies are the judgments. Sometimes the judgments are problematic for Louisiana. It depends on which parish.
Okay. Well, y'all figure that out. Do you need more time than a
No, ma'am,
week?
that's fine.
Ms. Holmes, you're sitting over there so quiet in the corner. I didn't even see you. You've got LaKendris Addison.
Yes. Good morning.
Good morning. Let's see,
and
this
Judge,
is a motion.
we have an agreement on this case.
Okay.
On count one, I'm gonna drop January 2022, February 2022.
Hold on half a second.
Oh,
Let me
sorry,
get that pulled up so I can make those. Okay. Count one.
And if it's okay with the court, we can proceed just on count one, but I was gonna drop the January of 2022 and February 20 of 22. He was taken into custody in Louisiana during that time, Your Honor.
Okay, gotcha. Okay. Good morning. Are you LaKendra Addison? And Ms. Holmes, will your client waive the formal reading of the indictment?
He will, Your Honor.
I'm sorry, the motion.
Yes, ma'am. Yes, Your Honor.
Mr. Addison, in cause number 21-36633,
Here's the thing, Addison isn't in trouble for a brand new crime. He's being sent back because he didn't follow probation rules. It sounds small, but in Texas, missing meetings can mean serious prison time.
I have a motion to revoke your community supervision. Shows that you were placed on probation September 15th of 2021 for the offense of burglary of a habitation. And that was a 10-year term that was suspended and you were placed on probation for 10 years. Is that correct? And then count one alleges that you violated your probation, and the state has amended that. Count one alleges that you failed to report as directed to the probation department October 5th, November 3rd, and December 2nd of 2021. And is that true or not true? True or not true? Count two alleges that, oh, I'm sorry, you going
If
on
it's
just
all right
count
with
one?
you, we can, Your Honor, if it's
Okay.
okay with you.
State abandons 2 through 5. Did you enter your plea of true to count one freely and voluntarily? And because it's actually true. I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand if I follow the agreement that you made with the district attorney, you'll be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Addison is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of true to count one freely and voluntarily. Find that count true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
Let's see. I gotta figure out how to do, the other day I figured out how to do a strike through. I gotta figure out how to do that again.
Ma'am.
Toy Hill.
Your Honor, you're taking 35 out of the cap. Right.
Toy.
Good morning. Are you Toy Hill? And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Hill, in cause number 25 DCCR 0650, you're charged with a third-degree felony offense of assault on a family member by impeding breath or circulation from January 24th of 2025. And how do you plead to that charge?
Guilty.
January. Did I say February?
You said January 24th.
January 24th, 2025.
Yeah.
Is that, are you guilty or not guilty?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they've charged you with?
Yes.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes.
And do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've made is for a 10-year term in prison, but that would be probated. You'd be on probation for 10 years. You would be ordered to pay a $500 fine and follow all of the rules and conditions of probation. Is that your understanding?
Yes.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number one.
No objection.
It's admitted. Is there any evidence that Ms. Hill is not competent?
No, Your Honor.
All right, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you.
Judge West shows patience here. Instead of rushing, she calls for a pre-sentence report. That means the final decision will be based on the bigger picture of Hill's life, not just one moment in court.
Guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Mr. Coleman, what is the state's position based on the nature of the plea agreement with regard to bond reduction?
Just for the court's information, I show a criminal history that includes a 4-year deferred on an injury to a child and a simultaneous violation of a protective order for 1-year probation, and assault, which was a misdemeanor, a resisting, and a theft, misdemeanor theft. I would have some concerns about.
What is your relationship now with Cheryl Johnson?
That's our mother. It's real good.
Okay, so let me ask you this. If you are released, when you're released from custody, where will you live?
With a friend of mine. My name is Tanya. 4555 Reed Road.
Reed?
Reed, R-E-E-D.
Uh-huh.
Road,
And where's that? What city?
Off of, Highlands. It's off of Highlands. It's Reed Road, but it's in Beaumont, Texas.
It's in Beaumont.
And
Because I want to make sure you understand that, at least for now, when you get out, you will not be able to have any contact with your mom, okay? And that's going to be very important, because if you do, if I let you out while we're waiting on the pre-sentence report and you have contact with her before we ever come back for sentencing, I don't have to accept this agreement, and things could be a lot worse. Do you understand? It's very important. So what I'm going to do, Ms. Hill, based on the plea agreement, is reduce your bond to $1,000. Okay? If you make that bond, you have a condition of that bond that you have to live at 4555 Reed Road with your friend. And if there's something changes and you need to live somewhere else, get with Ms. Holmes so that we know that. It is also a condition of that bond, if you make it, that you have absolutely no contact or communication with Cheryl Johnson. That means in person, obviously, but for now, that also means any contact, communication. Don't send her messages, don't text, don't email, don't Snapchat, don't, whatever it is, no contact. You understand? Okay. Even if she tries to say, it's okay, let's talk, I want to talk to you, you have to say no, because you're the one who will end up back in jail.
thank you.
Okay? So if for some reason you don't make that bond, probation will come talk to you at the jail, and then when you come back for sentencing, you would be released then. If you make that bond, then you also have to go straight to the probation department so they can do that report. So it's important that you do everything. They'll talk to you today and give you that information of where to go and all of that, okay? All right, you can go back with the bailiff.